my presentation will not be EU related, but focus on Council of Europe work, as you mentioned. And I think it's meant mainly at giving you an overview of existing legal principles and relevant work that has been done by the Council of Europe, which you would see in its principle and echo very much some of the issues that were raised, in particular in the introduction by Jaime and Celia at the very beginning of the seminar this morning. And I'll give you a little bit of insight into the recently adopted strategic action plan on human rights and technology in biomedicines, which provide for action that are also relevant to your own project in iConsent, as you would see. So just for those, I asked Sylvia whether I needed to make these introductions, but I thought it was useful for some people just to remind briefly about the Council of Europe. It's the oldest European institution, intergovernmental organizations. It's composed of 47 member states, which include the 27 of the European Union. And it aims at promoting democracy, rule of law, and strengthening human rights. And it's under that last pillar, strengthening of human rights, that the Council of Europe, since the beginning of the 18th, has been initiating specific activity on protecting human rights in biomedicines as an element of synergies toward the promotion of benefits of science, research, and in the field of health. Again, it's the idea of considering that human rights protections, if you address it, it's enabled to promote what is beneficial outside of the biomedical field, including biomedical research. And the reference instrument, which was adopted by the Council of Europe in 1997, is the Convention on Human Rights and Biomedicines, which will be at the center of my presentation then. So briefly, this convention, which is also called the Oviedo Convention, is a common framework for protection of human rights in biomedicines. It's the only legally binding international instrument in this field, and it acquires reference value not only at European level, and in that sense, it's worth noting that the EU Charter of Fundamental Rights referred to, it was inspired by the Oviedo Convention, in particular on the right to integrity article. But I think also quite importantly, the European Court of Human Rights has been using the Oviedo Convention as an instrument of interpretations for the Convention on Human Rights when it comes to health-related matters. And it's also become a reference instrument at global level with UN declarations referring directly to the Oviedo Convention. So the convention, and I'm not going to go further details in these general introductions, contain provisions that are referenced to daily medical practice, or more generally referred to as patient rights provisions. And it also addresses specific field of biomedicines, which have raised particular issue with regard to human rights, which is transplantation, biomedical research, and genetics. Now, I focus my presentation on the provision that concerns biomedical research. I say biomedical research because we don't have a focus on clinical trials at the EU level, but it's much broader in general. So the convention itself, the Oviedo Convention itself, contained legal provisions relevant to biomedical research, but those provisions were further developed and complemented in an additional protocol on biomedical research. There's also a non-legally binding instrument, a recommendation of the Committee of Ministers dated 2016 on research on biological materials of human origin, which is relevant particularly to biobanking. I will come back on this. And finally, something I would like to refer to, it's an implementation tool that is a bit older, but still, I think, at least to a large extent relevant. It's a guide for Research Ethics Committee members. It was really meant to try to help Research Ethics Committee implementing the provisions of the convention and its additional protocol. Now, I will focus in this presentation on consent provisions and in particular information related to consent, and explain why. Thanks. Well, it's something evident that consent is an essential clause for the protections of integrity, and it's a patient rights. The idea is not to act against the will of the persons. And that with HECO was set by Jaime at the very beginning. The Council of Europe has been approaching that notion really as a process to enable a person to make an individual choice. And in this process, to be able to make it possible for the persons to make that choice, appropriate information is an essential element, which is actually crucial for the validity of the process itself, again, independently of the consent system provided for by law. That's you know, the question I raised this morning about presumed consent or express consent is behind this. In all cases, appropriate information is crucial. And briefly to end on that slide, what I'm saying is that we heard, not this morning, but in different articles, publications, and conferences, and even people questioning the principle of informed consent. And it was not clear as to what level they were actually questioning it in relation to research. And I think what is important, if you really look at it from as a process, you may question the way it is implemented, but not the principle itself. And I think what is important now is to look at how this informed consent principle, which is a right and creating obligations, can be implemented to ensure this possibility of people to make choices with regard to, in the context of research, being on interventional research, or I would argue also in the context of research on their health-related data, which are sensitive personal data. So in the convention and its protocol, you see here the summary of the main feature of the provisions relevant to informed consent. Those are general rules applicable to for the Article 5 to any intervention in biomedical fields, so free and informed consent, no intervention without it, prior information appropriate, that is appropriate to means with regard to the format of that information as well as to its content, and the possibility to freely withdraw consent at any time, which imply that you need to be informed that something is going on, including in the case of the use of biological material which has been removed from at a certain time. The conventions include the provisions concerning biomedical research. And again, you see reference to the Article 5 of the General Conventions, but it's added to the requirement to free and informed consent that the consent has to be given expressly and specifically and be documented. Again, as part of the information to be provided, information about the right and safeguards, which include the right to withdraw consent, is also a requirement. The additional protocol further developed those provisions, and in particular with regard to the information, it detailed the information to be provided to the participant or potential participant in this context, and it gives some precisions about the format and the content, and it talks about information on possible future use, including commercial and use of the result of the research or the data and biological material resulting from this interventional research. If you look at the explanatory report on this of the Article 13 of the protocol, it gives some more precision on what means, what type of format, a comprehensive form, what it means, and it takes into account the individual situation of the persons concerned. Moving now to the recommendations, which is a more recent instrument. It's a result of an agreement among the 47 member states, I repeat. This is actually a work that has been carried out to revise a previous recommendation, which was adopted in 2006. And this work was carried out through different steps, including a symposium organized in 2012. And you could see the recording, the proceedings, the different interventions of the speaker in this symposium. And that includes also the European Commission's expert group on biobank, which was chaired by Herbert Godweiss and whose rapporteur was Jane Kay, who was mentioned this morning by Sørenholm. The symposium led to a draft revised recommendations, and in these revisions, much more emphasis was put on the governance of biobanks. There was a public consultation on the draft, and what was adopted in 2016 by the Committee of Ministers of the Council of Europe is the outcome of all this process again, which also involved different stakeholders who were all invited to comment on the draft and whose comments were taken into account. So the recommendations scope, as you see it stated here, look at the obtention of biological materials of human origin for storage for research purposes, the storage itself of such materials, and eventually its use in a research project for material stored initially for research or for material obtained for another purpose and then stored for research purposes. And what is an important element in this is that in all these provisions are considered to be applicable to biological materials for removed for research purposes, but also the associated personal data that are very often linked to these materials. And the purpose of this revision was, in particular, when it comes to informed consent, to see how this principle should be implemented in a biobanking context. So the slides here, again, focusing on informed consent, I think it's important again to insist on this information element that is so crucial for the consent process and for the person's consents to exercise their right to say no or to say yes to the use of their materials. So here you see that there's a whole article on informations requested prior to consent to storage for future research use. The research and these requirements are also about the form of that information. You see that I listed elements such as the nature of the research use that is envisaged. So obviously, we don't know precisely specific research projects, but we know possible research uses or field of research projects. Also, the possibility of the persons to make choices on the scope of their consent, on the type of research for which they would agree to get the material used and the one they would disagree. And also about the conditions applicable to the storage of material. And you see here access, policy transfer, condition governing the use of material, and that includes recontacting the persons or giving feedback on the result of the research in which their material has been used. And you see that this article acknowledged the fact that you may not know everything about the future use of that materials, but there is an obligation to be as precise as possible about the information you could provide, so that the persons can actually give a consent as informed as possible. And when it comes to consent, we'll see afterward the recommendations is excluded the possibility of blanket consent, which was also something referred to this morning. And again, one of the important elements in this is about information about the rights and safeguards provided for the person, in particular the right to refuse or to withdraw consent, including information on the possible limitations of withdrawal of consent if the material is already in use and some data have been already issued or resulted from the research that has been carried out. In the recommendation, I think there was an important point of information that has not been discussed this morning because we focused really on the individual informations, but it was about public information because it was felt that in addition to the information to be provided to individuals, it was important for people to be able to exercise their rights to have general information delivered at a higher level on the general policy, the nature and objective of research collections, but also general consent and authorization policy relating to the collection, storage, and use of biological material. Again, this is not replacing individual information with a view to consent, but it was felt that it was important at a time where there was an increasing use of material and data, and that could actually contribute to raising awareness on this and enable people to better exercise their right over the material that may be collected and data collected. Regarding consent, the recommendations, I didn't focus on person not able to consent, I focus on person able to consent, but you see again element that you find in the conventions when it comes to storage for removal for storage for future research, prior free, express and documented consents, again as precise as possible with regard to the envisaged research used. And when it comes to biological material that has been previously removed for other purposes and now is stored for future research use, the consent is required, as mentioned. And I think the recommendation is not prescriptive as to the modalities of consents, but what is actually underlined in the explanatory report to this recommendation is that in all cases it is essential that appropriate information is provided about the consent regime applicable and with regard to the consent request about the future use of this material. So again, stressing the needs for information as a key element in the entire process. A whole article is dedicated to ROS to withdraw consent or authorizations. You see here also an element that was very much discussed because it was felt that it was important that people are informed of this as soon as possible. And one of the things which was suggested is that when you are in a healthcare context and material is removed that would possibly be used for future research, that you are asked already at that stage to provide consent to further use of your storage for research purposes and further use of your material for research purposes. So try to anticipate that rather than having to recontact the person afterwards. My last slide on the recommendation 2016-6 and is on governance, because this is one of the important additions to the recommendation adopted in 2006. It's about the governance principles related to biobanking, and you see again the importance of information. I try to highlight that's transparency and accountability, but also in the needs to attach information about scope of consent, initial consent to any single samples, the need to ensure appropriate security and confidentiality, that any participant or people having accepted to give material to biobank be informed about management and use of the collection available. That has to be regularly updated. And again, this requirement is to enable the persons to exercise their right to withdraw consent if they would like to, where appropriate, and also more transparency toward the general public on the activity of the biobank. And again, that is contributing also to this transparency principle. And I think it's also important when it comes to building trust in the whole system. I haven't actually put it on the slides, but there's also a provisions that concern individual feedback policy in the recommendation itself, which say that it's not prescribing any type of policy, but it requires that such policy be actually in place and that people are well informed about it, so that when they decide whether or not to give their samples, they are well aware of what to expect. And I think there was previous cases, including in UK Biobank, where this appeared to be a misunderstanding by certain people. So it was felt important to specify that from the very beginning in the recommendation. I stop here for the existing legal instrument. As I said, it's really an overview. I hope it's informative. And I think that for me, it was important to refer to this recommendation because I think it's provide a legal basis for many of the issues that that you would like to address in the iConsent project. I will move on to the strategic action plan that was announced by Sylvia. This is a brand new initiative that was adopted actually in November last year and has been launched at the beginning of this year. It will cover 2020 to 2025, and it's the result of a 2 years analytical process, which started with a conference on the 20th anniversary of the Oviedo Convention, with the objective of looking at the relevance and of the provisions laid down in that conventions to address new human rights issue raised by development and biomedicine. It was felt indeed that there was a sort of a turning point, that was the expression used, in human rights and biomedicines linked to development of technologies, emerging and converging technologies, but also evolution of the practice. And the analysis was done through questionnaires addressed to at national in the different member states to different stakeholders, asking them what they consider to be a priority issue to be addressed at intergovernmental level, priority in terms of human rights issue raised by the development, both linked to technological development and to evolution of practices. And the idea was, again, the synergy that human rights are progressive and are enabling for advances in science technology. And by addressing human rights, you're promoting what could be beneficial for human health. So the result of this 2 year analysis can be summarized with the 3 conclusions that are on that slide. First conclusion, that the feature of new technologies challenge existing governance, speed of development, blurring of breaking of boundaries for application, complexity and uncertainties, difficulty to understand and anticipate risk are all calling for new governance model that needs to be developed. The second conclusion was, or result of this analysis, that the emergence of new technology and the changing demographic context pose significant social challenges for all member states. This was an increasing disparity in access to healthcare in particular, and linked to social and demographic changes. We'll see that in particular with certain people like older persons or migrants having difficulty to accessing healthcare, and high cost of new treatment and healthcare technologies. And the third concluding elements, which was formed the basis for the strategic action plan, is the unprecedented challenges for mental and physical integrity linked to technological development, particular neurotechnologies, and genetics and genomics, as well as evolution of practices with a new perception on the balance between protection and autonomy, for example, on children's, older persons, or persons with mental health. That brings about novel questions about autonomy, privacy, and freedom of thoughts. So I would not go into the detail of the strategic action plan, but summarize. I hope you can read what are in the boxes. Otherwise, I encourage you to look at the documents that Sylvia may have shared with you. I sent her the strategic action plan, the entire document in electronic versions. But in summary, the strategic action plan is structured around 4 pillars: governance, equity, and integrity, as well as cooperation, communication as a transversal one. And under each pillar, some specific objectives have been identified, leading to a series of actions. So I think for the sake of time, I don't go into the details of this, but I wanted just to highlight a couple of actions that are linked to those specific, some of the specific objectives, which may be particularly relevant and of interest for you, because they will touch upon consent-related issues. The first 3 actions are relevant to the pillar of governance. One is linked to the need as a specific objective to reconnect biomedical technology with ethical values and human rights. The idea is being that governance should be guided by values rather than potential applications and technically driven, so to say. One of the action is to assess whether the existing human rights framework to address is appropriate to address neurotech applications. And here, Marcelo Yenka will have certainly a specific input into these actions. The second one is about AI. There's many initiatives related to AI, including in healthcare. And the idea of the committee was to foresee a work that will be of added value, complementary to the general initiative that could have been taken, and decided to focus on impact on patient-doctors relationship. And finally, in relation to governance, the action I wanted to highlight is the one which is linked to the second specific objective, which is to ensure democratic, legitimate, and effective governance and technology, with the idea that that there was need for trust in science and medicine, and to do that, human needs and public expectations were duly to be considered, and therefore that public discourse was integral part of new governance. And there was a wish to particularly focus on the development in genomic medicine. And the idea of this action will be to promote dialogue between different stakeholders, including publics and practitioners, to ensure that patient and public interest are key priorities in the development and regulation of genomic medicine. So again, I'm not going to go into the detail of the actions. We are working on the methodology, but I think that there might be a lot of relevant issue addressed in that actions to the I project, and the conclusion of your own project would be quite important in the context of these actions to be undertaken by the Committee on Bioethics. And the last action I wanted to mention, and I was really interested in listening to Jaime when he mentioned the clinical trials on children's, because one of the actions foreseen in cooperations with the Steering Committee on Children's Rights of the Council of Europe is to develop a guide on good practice for the participation of children in decision-making process regarding matters relevant to their health. And that would include biomedical research. So I think here again, the outcome of the I Consent project would be extremely interesting. And I was thinking also about Sally's competence, and I was thinking that maybe we should get in touch with each other after the seminar to see how we could benefit from your expertise and possible input through the also I project. Now, in conclusions, I think coming back to the idea that is guiding all the work of the Council of Europe in as a fundamental principle, to say that consent is a process aiming at enabling a person to make an individual choice, and that is a right that creates obligations to ensure that the person has the possibility to exercise these rights. That for any system of consent or authorization that could be considered, prior appropriate information, including about the rights to refuse or withdraw, is an essential element, and it's crucial for the validity of the process, whatever form it takes. New development in biomedical research, as we've seen, require to consider and develop the conditions for respecting this individual right to consent, and I think the I consent fits very much into this these elements, and the work done by the Council of Europe and the legal instruments I briefly refer to in these presentations constitute reference value for developing practical guidance for the, would say, new way of looking at implementations of the informed consent. And as the last point, as I ended my presentations, referring to the Strategic Action Plan on Human Rights and Technology in Biomedicines 2020-2025, as you see, there's a series of targeted actions that would actually be also looking at issues that are relevant to consent, and for which I think the work you are currently doing in the I project, which would be extremely interesting, not to mention the individual expertise of those who are participating in this webinar today. And I thank you for your attention. I'm ready to answer questions.